Tennessee is now in session.
Good morning. Before we call the case, just one brief statement here. We don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and we'll pause and we'll get it corrected and then we'll proceed from there. Mr. Hivner, if you will, please call the case.
State of Tennessee ex rel. David Jonathan Tulis versus Bill Lee, Governor of Tennessee et al.
Mr. Tulis, we'll hear from you, sir, as the appellant.
David Tulis, I'm starting with two citations. Jacobson versus Massachusetts. SCOTUS and the United States oppose, quote, regulations so arbitrary and oppressive as to justify the interference of the court to prevent wrong and oppression. That's 197 U.S. 11. Also, Kennedy versus Head, 1945, the only case touching what is now 68-5-104. It's a crime when the health official, quote, fails to perform the duties required of him in this statute. 68-5-104 is now enforceable criminally only through the official misconduct statute at 39-16-401 felony statute. Chancery refuses to reprove and correct two respondents involved in criminal activity. It rejects the forthwith part of the mandamus statute, which is to say a 14-day max in the federal standard, 14 days max for a peremptory petition where all the facts of the breach in the complaint are taken true. This case is in the 501st day, 201 days in Chancery Court. Chancery denies relief, justice, equity, and the black letter law. Does the court plan to cooperate with the lower court? Chancery has no substantial order on petitions, my petition's supposed lack of adequacy and sufficiency. It has proposed a fraudulent standing thesis violating 29 Chapter 5. It issues 4 orders, the last 2 more damning than the first 2 dismissal orders, which I obtained to set a record of the wrongs being done to the state of Tennessee ex rel. And the people. Chancery writes in generalities, there's no standard by which my petition fails. Chancery rejects a petition that I didn't file. The court adds to the harm of the respondents in fraud and to me personally and the 6.8 million people I represent in this hearing. Dragging out a cause and delay add to injustice and our injustice, Gibson says. Fraud exists in Tennessee courts of equity. This court must banish, stop, destroy, expose, abolish fraud, and correct official misconduct by a man and woman operating in their personal capacities apart from their offices, and they're doing it under coloration of law. My petition is adequate. It is sufficient. The exhibits are not denied. Fraud is admitted, and it is not avoided for 501 days. Gibson says that equity will not allow a misstep in form or a defect in procedure to protect parties in fraud. My petition properly empowered Chancery to do the right thing for relief of me and the people. The petition empowers this court to do likewise without a demonstrable infectious agent. There's no true remedy in the health of the people. If there's not a non-fraudulent exigency or cause, there cannot be a lawful operation of the executive branch of government. Allowing the orders below to stand means that fraud has safe haven in Tennessee. It breaches separation of powers where the governor can do what he wills to legislate. The judiciary writes a new mandamus law redefining the word forthwith to mean something other than immediately, if not sooner. And it also fails to safeguard the legislative prerogatives in the Tennessee Code annotated. And allowing the orders to stand, this court would deny the guarantee that I have and that anybody else has to challenge law-breaking, law violating officials. The harms in this case, as I've exposed in my petition, are like that of a cop who arrests someone without on a hunch, right? On a feeling, maybe a personal animus, maybe profiling a member of the public. No probable cause, no warrant, no articulable suspicion. He's not serving an indictment, so there's no lawful reason or cause or basis for the arrest of that citizen. Well, that's what's happening in this case here. We have we have me bringing before the court of Chancery and this court 2 cops who have made an arrest they claim is lawful, but it's not lawful by any means of the imagination because there's not that essential element. An adequate and sufficient complaint is filed in this case. There's the petition, there's the affidavit of support, there's the interest on the part of the relator, that's me. I'm a citizen, I'm not an officious intermeddler, as one case says. There's the duty of the officials involved. 2925-102 says that the alternative writ of mandamus says that the official must do the act or show cause at a hearing. The peremptory one that I asked for commands the defendant to do the act or to return the writ, and all forthwith, all immediately, if not sooner, Your Honor. Chancery should have looked at the exhibits. If they were clear, then it should have issued the peremptory writ. If they were not clear, if there was some debate, it should have issued an immediate summons to have a hearing in chambers. I filed on Friday. It should have been by Wednesday at the latest. A conference with the respondents to show cause. Gibson says cause is, in the maxims, is a good, legal, substantial, meritorious reason for what they're doing. Did the cop have a warrant is the question before Chancery. Was the cop acting under presumption? Was he acting under a fraud? Was he cheating due process, as cops like to do? The respondents have acted presumptively from the get-go. They've acted without what is pointed out required in 68-5-104. The emergency had to be based on some legitimate thing, some fact or action. There had to be a determination made, the contagious principle as it's described in Chapter 1 of Title 68 to be found. At that hearing that Wednesday in chambers with the judge, respondents could have avoided the fraud in the record. They could have evaded the fraud. And of course, an evasion is an unlawful dodging of a lawful duty. They could have done that. Well, Chancery all this time has allowed evasion. If the respondents were true and honorable and obedient to the law and to their oaths and to their terms of employment, they simply could have been at that meeting and showed that they were obeying the law, that Mr. Tulis just got something wrong. Well, we forgot to give him this in open records. Well, he didn't ask for the right thing, and here's all the evidence that he really was looking for, showing we complied. But Chancery didn't order that and accepted evasion. It accepted fraud as equitable. That's where things stand right now. Fraud is equitable. The petition was true. It was sufficient. It was not avoided. I have standing. I've had it from the beginning. I have been prosecuting this case diligently. It has been a diligent prosecution. Notice my motion pro confesso. It was denied, and that Chancery's orders of dismissal failed to reflect that the pro confesso should have ended the cause immediately. I filed it 15 days after filing the petition. It nailed and admitted fraud in the record prior to filing and with the filing. Chancery, in its maybe in spite of itself, has admitted that there's no cause to the emergency. Let me tell you how it did that. Despite itself, it admits all my claims. And here's how. It says that Lee is not under, quote, any duty to obey 68-5-104, and that he didn't obey. Any, of course, is italicized from Kleinfelter's brief. But the law is the only basis for a health emergency premised on a communicable disease. That is to say, 68-5-104 has to be premised on a statute. There was no epidemic finding in Hamilton County. I don't think in any other county in the state. If Chancery says 68-5-104 is ignorable and admits it was ignored by the respondents, well, then it admits there's no basis or cause or a warrant or lawful reason for the arrest of the citizen by the cop, right? No basis for a Title 58 emergency. Again, admitted in the rulings of Chancery. I stand on my due process grounds, my due process rights. Procedurally, Chancery does not show in its orders how fraud was avoided or that fraud wasn't happening from the beginning. The court cannot agree with fraud. accepting incorrect orders is a fraud on me and a fraud on the people of our state and the state itself. Equity principles require an immediate showing that fraud did not occur. Failure to do so admits the respondents' fraud did occur because the petition is taken true. Respondents' compliance is my due process protections. They didn't comply with the statute. I've had no due process protection. I face ongoing irreparable harm without a remedy if this court accepts Chancery's lawyerly gazoozling, Your Honor. Thank you. I reserve my time.
Yes, sir. You have your time for rebuttal. We'll hear from the appellees. I understand you've divided the time. Is that correct?
That's correct, Your Honor.
And who will go first?
I will, Your Honor.
That'll be fine.
Thank you. Janet Kleinfelter with the Attorney General's Office, and I'm here on behalf of Governor Lee. Your Honor, this was a petition for writ of mandamus, seeking to mandamus Governor Lee to compel him to comply with or to perform his duties under Tennessee Code Annotated 68-5104. The trial court dismissed the petition for writ of mandamus against Governor Lee and did so correctly for three reasons. First of all, this was a petition brought against the governor in his official capacity. Therefore, it is a suit against the state. And as such, the governor can only be sued in Davidson County. The case law and the statutes make it clear. Tennessee Code Annotated 4-1-205 makes it clear that Davidson County is the seat of state government. And of course, the governor is the chief executive officer for the state of Tennessee. Additionally, 29-25-104 states that when a writ of mandamus is being brought against a public officer, it can only be brought in the county in which the office is kept. Again, that is Davidson County. And this court recently, in the case of Walker versus Tennessee Department of Human Services, a January 2021 decision, and that is 2021 Westlaw 120941, found, in fact, that was the case, held that in that instance, the writ of mandamus petition could only have been brought against the Tennessee Department of Human Services in Davidson County, and held that the action brought in Shelby County, the Shelby County Chancery Court, was without jurisdiction because those statutes making venue localized resulted in it being jurisdictional. So that's the first reason. The second reason, and this is undisputed, is that the governor is simply not subject to mandamus. The Tennessee Supreme Court, in the cases we cited in our brief, has recognized for over 100 years that that no courts have jurisdiction to compel the governor by mandamus to perform any official duty. So that is the second reason why the trial court was correct in dismissing the petition for writ of mandamus. And the third reason is quite frankly, if you look at the petition and you look at the statute, petitioner simply fails to demonstrate that the governor has a clear duty to act. Of course, the case law is clear. In order to be entitled to a writ of mandamus, which is extraordinary remedy, a petitioner has to show that the relief sought is clearly established, that the defendant has a clear duty to perform the act at issue, and that no other plain adequate remedy exists. And here, the trial court looked at the statute 68-5104 and found that it imposed no duty on the governor. It doesn't even mention the governor. Now, petitioner has, of course, argued and will probably argue before you today, well, the governor has commissioners, such as the commissioner of the Department of Health and other agents who can act on his behalf, and he has a duty to require them to act on his behalf. But Your Honor, that was not an argument that was raised in the petition for writ of mandamus. It was not raised in responding to Governor Lee's motion to dismiss. It was an argument that was raised for the first time in the petitioner's Rule 59 motion to alter or amend the final order. And this court has repeatedly recognized that a Rule 59 motion is not the proper vehicle for raising new arguments. And therefore should not be considered. But even if the court did consider it, as the trial court noted in its order, if you look at the statute in question, it clearly imposes no duty whatsoever on the governor. So for those reasons, Your Honor, we would respectfully request, we submit that the trial court correctly dismiss the petition for writ of mandamus against the governor, and would respectfully request that this court affirm that judgment. Thank you.
Thank you. We'll hear from you now, please.
Good morning, Your Honors. Like the state's argument, we would.
Counsel, introduce yourself first, please.
Oh, Sharon Milling for Rebecca Barnes, Your Honor.
Thank you.
Like the state, we would ask the court to affirm the trial court's order as it was correct. Relative to Ms. Barnes, Mr. Tulis has suggested that she was somehow in violation of the statute. The court determined that he noted in its order that he had not said he was subject to the statute because he had not been diagnosed with COVID-19, and that therefore the statute didn't apply to him. In addition to the reasons outlined by Ms. Kleinfelter, this is an additional reason as to Ms. Barnes why the statute does not apply and he does not have standing under that statute. Further, the court also found, and I think Ms. Kleinfelter has already addressed this, that because Ms. Barnes had discretion in making a decision, and the statute particularly says, Tennessee Code 68-5104A1 says local health authorities are to take such steps as may be necessary, indicating that there is discretion with how they act relative to this statute. The court found that the duty was indeed discretionary, therefore mandamus was not appropriate because there was not an act to compel. Moreover, the court found that Ms. Barnes had discretionary function under the Governmental Tort Liability Act. She had immunity relative to that discretion. For these reasons, Your Honor, we would say that the court appropriately made these decisions, that Mr. Tulis was not denied any due process as this was heard repeatedly, and that the court's decision was correct, and we would ask that you reaffirm that.
Thank you.
Thank you.
Mr. Tulis, you have your time for rebuttal. We'll hear from you, sir.
Yes, Your Honor, thank you. To say that Mrs. Barnes has discretion to ignore the statute and the many steps in it simply because there's a phrase within the statute that says as may be necessary is a joke. It's a joke to say that discretion operative within obedience gives the persons liable to the statute the option of ignoring the entirety of it. That's not how the law works. It is not, especially when there has to be a determination made of the agent of contagion and in a communicable disease crisis. And here we have the health department in Helena County saying that, well, the main statute dealing with epidemics, dealing with communicable diseases, we can ignore because there's discretion operative within the confines of obedience to the statute with all of its parts. The parts cannot be ignored just because at some point an official has recognized by statutory language the right to use discretion. Of course, discretion operates continually in the operation of an office like that. So this is a bogus argument, a specious argument, because these people I've caught in flagrante delicto, in the middle, if you will, in the middle of an adulterous orgasm, if you will, and I caught them at it, and that's the statute, 201 words of legislative type and command to them, and they are caught with their pants down, and there's no way around it, and Chancery has agreed with them, and I'm demanding that this court stop this travesty, this violation. And also for Ms. Milling to say that I'm subject to the statute, somehow have standing only if I'm somehow offended by the statute, doesn't understand how the law works. I read her briefs on this, and I don't understand where this idea comes from. I just cannot fathom that I'm subject to the statute. I'm not. Okay, these people in government offices are. The question about that Ms. Kleinfelter raises regarding Latour v. Frazier and the other cases that say the governor is not subject in any manner whatsoever to mandamus, it is simply wrong. These cases are dealing with policy differences, disputes about how the government is run, but none of them deal with fraud and crime. This case is about a fraud and mass crime in a mass casualty event brought about by government actors, with the remedy to the flu being the experimental jabs project, not FDA approved, bringing, I dread to say, mass death upon the people of this state. Latour and the other cases that the governor cites and that Chancery agrees with do not deal with fraud. Those cases, none of them deal with this situation. We are in an unprecedented overthrow of democratic institutions, a coup and a putsch against the Republican form of government and constitutional government. She says that the governor has no duty to act, no clear duty. He's not named in the statute. Again, these are frivolous arguments to say that being named in a statute is how you come under it. That's not how the law works. How many thousands of lines of type in the Tennessee Code don't name the party who's got the duty and liability? It doesn't work like that. The duty of the governor, I have evoked from the beginning. It's not a new argument. And that is my filing makes reference to Dr. Piercy. He has agents, and his excuse for not obeying the law is that I have agents. And to put it that way in a late filing is not a new argument. It's not a new argument. He's saying, because I have an agent, I can't be attached. Liability does not attach to me. Well, since when does a governor get to separate the agency principle, the agent principle construct? That construct exists in government, and he is bound under his duty in the Constitution to see to it in the subjunctive tense that the statute is obeyed. He has liability. I have no business suing Mrs. Dr. Piercy. I sue the proper person who's got liability, fiduciary duty to obey the statute and respect the rights of the people. My due process rights have been overthrown. Mrs. Kleinfelter says that the case is dismissed correctly, only filed in Davidson County. Again, my analysis in my reply brief and my main brief point out that those cases apply to commissioners, and it is a very tortured reasoning to get it that that only in Davidson County can a man accused in his person of fraud, mass fraud, be sued in his choice of venue. It doesn't work like that, Your Honor. Thank you.
Thank you, Mr. Tulis. Court's thanks to both sides for your oral argument and your briefs. Mr. Tulis, you may already be aware of how the process works from here out, but let me just say it to make sure. The court will take the case under advisement. We'll issue a written opinion and judgment. It'll be served on you and the opposing counsel at the same time. And that's how we'll notify everybody of our decision. All right. Thanks again for the oral arguments and the briefs. Mr. Hibner, if you'll recess court until tomorrow.
This honorable court is now recessed until 1:30 p.m. this afternoon.
Thank you for correcting me.
Thank you.
Thank you.